posted on our website right now if you want to go and download those slides. They are posted on the events page of our website, www.texasrealestate.com. So if you want a copy of the slides, they're available now. The recording, we are recording this webinar. So if you missed something, you want to go back and listen, or if you just want a copy of it, the recording will also be posted on that same events page of our website, texasrealestate.com. You'll also receive an email after the conclusion of today's webinar, and that email will contain a link to the recording. Last but not least, questions. If you have questions, go ahead and type those in as we go. We will be reserving some time at the end for questions. So let's get started here. First, an outline, a roadmap of what we'll be talking about today. So I want to do a brief introduction. Then we'll hit some of the definitions that are important when understanding security devices. We'll talk about application, what properties this applies to, what properties it does not apply to. We'll talk about requirements, security devices required without a tenant's request, those required with a tenant's request, and then repair or replacement requirements. We'll talk about tenant's remedies. If the landlord fails to comply, what the tenant can do. We'll also talk about defenses, both for the landlord and the property manager. And like I said, hopefully we'll have some time at the end to answer any questions you have. So an introduction. So you're going to find the requirements for security devices in the property code. It's Chapter 92, specifically Subchapter D. Now, Texas law requires that most rental properties have security devices in place while a tenant is in possession. If they don't, a landlord can face liability. Now, why is it particularly important to understand these requirements? And that is because of the definition of landlord. So generally, as you probably know, under the property code, Chapter 92, landlord is defined as the owner, lessor, sublessor of a dwelling, but does not include a manager or agent, unless the manager or agent, according to the definition, purports to be the owner in an oral or written lease. What's different or unique about the security device subchapter, however, is that it has its own definition of landlord, and it's defined as a dwelling owner, lessor, sublessor, management company, or managing agent, including an on-site manager. So you can have liability as a property manager under the security device subchapter because you can be considered the landlord. Now, what's really important to note here is that just because you can be considered a quote-unquote landlord under this law doesn't mean you can or should be installing or repairing security devices yourself. First, the property management agreement, the TAR property management agreement, doesn't expressly authorize you to do so. But second, perhaps more importantly, ordinarily installing or repairing what's called mechanical security devices like deadbolts and locks actually requires a locksmith license. Now, just like anything, there's always exceptions, and one of the exceptions is that the license requirement, a locksmith license requirement, does not apply to a person who is on the person's own property or on property owned or managed by the person's employer. They could install or repair a mechanical security device. They could repair an electronic security device. They could make a key for a security device. So in sum, what does that mean? A landlord, someone who actually owns the property, could install or repair a security device. An employee of the landlord could install or repair a security device. And an employee of a property manager could install or repair a security device. But because most of you as property managers are independent contractors, you're not included in this. Now, this may not be a big deal for most of you because your landlord may already use a locksmith company to comply with these requirements, and that's certainly an option, but definitely something to be aware of. So when we talk about security devices, what are we actually talking about? Well, under the property code, a security device means all of these things. All of these things can be considered security devices. A doorknob lock, a door viewer, a keyed deadbolt, a keyless bolting device, a sliding door handle latch, if you've got a sliding door pin lock, sliding door security bar, and a window latch. So we're going to go through these definitions one by one. If I have pictures, I'll include them. The photos or the pictures I'm going to be using are really for representation only, to assist those who are more visual. I know that's certainly me. But make sure you're using the definitions themselves to comply. These are just, of course, examples. So first and foremost, a doorknob lock. So a doorknob lock, as the name might suggest, is a lock in a doorknob, with the lock operated from the exterior by a key card or combination and from the interior without. So you might have this setup here where you've got a key in or a key ability to open with the key on the exterior, and then a lever or knob on the inside and the interior. What about a door viewer? Well, a door viewer is a permanently installed device in an exterior door that allows a person inside the dwelling to view a person outside the dwelling. And the device has to either be one of these two things: a clear glass pane or one-way mirror, or a peephole having a barrel with a one-way lens of glass or other substance providing an angle view of not less than 160 degrees. So it's pretty specific. Sometimes we get a question, well, you know, there's windows right next to the door where someone could see who's outside, standing outside in front of the door. So sometimes we get the question whether a door viewer is necessary in that instance. Well, if you're strictly reading the statute and the language they use, the definition says in an exterior door. So relying on a nearby window may not be complying with the statute. All right, next up, a keyed deadbolt. So it could be one of two things. A keyed deadbolt could be a door lock not in the doorknob that, one, locks with a bolt into the door jamb, and two, is operated from the exterior by a key, a combination, and from the interior by a knob or a lever without a key or a card or combination. So that's one option. It could also be a doorknob lock that contains a bolt with at least a 1-inch throw. So here's an example of that first category, the pictures, where you've got a key on the outside, you've got to use a key on the inside, or on the outside, but you use a lever or a knob on the inside. Next, a keyless bolting device. Now, actually, there are 3 options under the keyless bolting device definition. The first one that I'm going to talk about is probably what is most frequently used and probably the easier to find. But there are 3 options, so it's good to be aware of what the 3 keyless bolting device options are. So first, it's a device, is a door lock not in the doorknob that locks, and you'll see this long definition, with a bolt into the strike plate screwed into the portion of the door jamb surface that faces the edge of the door when the door is closed, or into a metal door jamb that serves as a strike plate, operable only by a knob or lever from the interior and not in any manner from the exterior. So commonly known as a keyless deadbolt. So here's a picture of what it might look on the interior. There's nothing on the exterior. You'll be thankful I'm not going to read that entire definition there, but the second option, again, that may not be as frequently used, but the second option is a door lock not in the doorknob that locks by a drop bolt system. And essentially that drop bolt system must prevent the door from being opened unless a central plate is lifted off of the door jamb restraint by a person who is on the interior side of the door. That's the second option. And then the third option under keyless bolting device is a door lock not in the doorknob that locks by a metal bar or metal tube placed across the interior side of the door. When secured to screw hooks, the bar or tube must prevent the door from being opened. unless the bar tube is removed by a person who is on the interior side of the door. So again, all of those three things can comply with or equal a keyless bolting device, but that first one I mentioned might be the most widely used. Now let's switch gears a little bit here to a sliding door handle latch. So if you have sliding doors, a sliding door handle latch is a latch or lock located near the handle, operated with or without a key, and is designed to prevent the door from being opened. So what you see on the screen might be an example of that. Sliding door pin lock is a lock on a sliding glass door that consists of a pin or nail inserted from the interior side of the door at the side opposite the door's handle, and that is designed to prevent the door from being opened or lifted. And then finally, for sliding doors, a sliding door security bar. It's a bar or rod that can be placed at the bottom of or across the interior side of the fixed panel of a sliding glass door, and it's designed to prevent the door from being opened. So there's a picture of what that might look like. Last but not least, we have the window latch. It's a device on a window that prevents the window from being opened, and that is operated without a key and only from the interior. So that sums up the definitions of what a security device can include. Let's switch gears now and talk about application. So the security device requirements, they are not going to comply or require every single rental property to comply with the statute. The first question you have to ask yourself is, do you own or manage rental property? And under the statute, the type of property we're talking about is a room in a dorm or rooming house, a mobile home, a single family house, duplex or triplex, and a living unit in an apartment, condominium, cooperative, or townhome project. So do you own or manage any of those types of rental properties? And you may be asking, why are you asking if I manage? Well, remember, the definition of landlord can include a management company or managing agent. So both of those, whether you actually own the property or you manage, are important to establish. Now, if the answer is yes, you do own or manage one of those types of rental properties, the next question you have to ask yourself is the rental property one of these four categories? Is it a room in a hotel or motel? Is it residential housing owned or operated by a college or university? Look at that fourth bullet there. Is it a temporary residential tenancy created by a contract for sale in which the buyer occupies the property before closing, or the seller occupies the property after closing for a specific term not to exceed 90 days? Now, for some of you who engage in sales, that language might look familiar to you. If you're familiar with the seller's temporary residential lease and the buyer's temporary residential lease, you'll note at the top of the form, it actually states for use only when seller occupies the property for no more than 90 days after the closing, or, that's for the seller's temporary residential lease. It'll have similar language for the buyer. So basically, if it's a temporary residential lease, the security device requirements don't apply. So that's the requirements or whether the statute actually applies to a particular rental property. If they do, let's actually talk about what the requirements are. So there are really two categories of security devices, and I think it's particularly helpful to break security devices into two categories. And if you can use that framework throughout the seminar, I think it makes things a little more clear, a little more helpful. So category one, those are security devices that the landlord must install at the landlord's expense without a request from the tenant. They've got to be there. Category two are security devices that the landlord has to install, but only at the tenant's request and at the tenant's expense. So we're going to talk about both of those in turn. But really, why am I breaking these down other than I think it's helpful? Well, it's important to distinguish between those two categories because the tenant's remedies will vary depending on which type of security device is in question. So again, it's important to be able to break those down and understand which category or group we're talking about. Now, before I get into the differences, I do want to talk about some general requirements that apply overall. So generally speaking, a landlord can select the type or brand and manner of installation, including placement of a security device. However, there are height, strike plate, and throw requirements for keyed deadbolts, keyless bolting devices, and sliding doors. So what are those requirements? Well, if we're talking about height, strike plate, and throw requirements for a keyed deadbolt or keyless bolting device, here are their requirements. First, a keyed deadbolt or keyless bolting device cannot be higher than 48 inches, and it cannot be lower than 36 inches from the floor. A keyed deadbolt or keyless deadbolt must have a throw not less than 1 inch, and a keyed deadbolt or keyless bolting device must have a strike plate, either one, screwed into a portion of the door jamb surface that faces the edge of the door when the door is closed, or two, be installed in a door with a metal door jamb that serves as a strike plate. What about sliding doors? What are the height or strike plate or throw requirements for sliding doors? Well, there's a height requirement. A sliding door pin lock or sliding door security bar must not be higher than 48 inches. Fixtures. So generally, once the security device is installed or changed, they become fixtures of the property. And so a tenant cannot remove or change or replace or alter the security device without permission from the landlord. Now, there is an exception to that, which we'll get into later, where one of the remedies that a tenant can take if a landlord fails to comply is to repair the security device themselves. But we'll talk about that in a moment. Now, if there is one slide out of this entire presentation that you should remember, it is this one. Flag it, star it. This is an important one. So we are now talking about those Category 1 security devices that a landlord has to install at the landlord's expense without a request. They have to be there. So a landlord has to equip the rental property with these things, these 5 items, or 5 points rather. So first, a window latch has to be on each exterior door. Second, either a doorknob lock or a keyed deadbolt has to be on each exterior door. If you've got sliding doors, a sliding door pin lock has to be on each exterior sliding glass door. A sliding door handle latch or a sliding door security bar has to be on each exterior sliding glass door. And then finally, a keyless bolting device and a door viewer has to be on each exterior door. So what do we mean when we're talking about an exterior door? Well, the statute defines it as a door providing access from a dwelling interior to the exterior. It includes a door between a living area and a garage, but does not include a sliding glass door or a screen door. Now note, these requirements apply only when the tenant is in possession of the property, and possession means occupancy by a tenant under a lease, including occupancy until the time the tenant moves out or writ of possession through eviction is issued by the court. So these are the minimum. These are the things that have to be done without a request from a tenant. Now I'm going to talk about French doors next. There are some specific requirements if a property has French doors. So if the rental property has a French door or French doors, one door of each pair of the French doors must meet those Category 1 requirements, what was on the previous slide. But the other door must have either a keyed deadbolt or keyless bolting device capable of insertion into the door jamb above the door and a keyless bolting device capable of insertion into the floor or threshold, each with a bolt having a throw of 1 inch. The other alternative is a bolt installed inside the door and operated from the edge of the door, capable of insertion into the door jamb above the door, and another bolt installed inside the door and operated from the edge of the door, capable of insertion into the floor threshold, each bolt having a throw of 3/4 inch or more. What do we mean by French doors? It means a set of 2 exterior doors in which each door is hinged and abuts the other door when closed. So there are specific requirements for French doors in addition to your more typical exterior door that you might think of. Now, just like any general rule or requirement, there are exceptions. Of course there are. So the first exception deals with a keyless bolting device. So a keyless bolting device is not required to be installed at the landlord's expense on an exterior door if all of these 3 items are true. This is a pretty narrow exception. I don't know that most of you will run into this, but it's good to know. So a keyless bolting device is not required if the dwelling is part of a multi-unit complex in which the majority of the units are leased to tenants who are over 55 years of age or older, or who have a physical or mental disability. A tenant or occupant in the dwelling is over 55 years of age or has a physical or mental disability. And third, the landlord is expressly required or permitted to check on the well-being or health of the tenant as part of a written lease or other written agreement. So again, that's a pretty narrow exception. There's another exception, dealing again with the keyless bolting device. It's similar in nature, not required to be there if a tenant or occupant in the dwelling is over 55 years of age and has a physical or mental disability. The tenant requests in writing that the landlord deactivate or not install the keyless bolting device. And finally, the tenant certifies in the request that the tenant or occupant is over 55 years of age or has a physical or mental disability. Now, that request has to be a separate document, can't be part of the lease. And a landlord is not actually going to be exempt if the landlord knows or has reason to know that this isn't true, that these requirements are not fulfilled. So again, another pretty narrow exception. Now, this third exception may apply to more of the properties that you manage or that you own. So a keyed deadbolt or a doorknob lock, remember, that was one of the requirements, that a landlord has to equip the dwelling with either a doorknob lock or keyed deadbolt in each exterior door. So this is an exception to that. It says a keyed deadbolt or doorknob lock is not required to be installed at the landlord's expense on an exterior door if, at the time the tenant agrees to lease the dwelling, at least one exterior door usable for normal entry into the dwelling has both a keyed deadbolt and a keyless bolting device installed in accordance with the property code requirements, and all other exterior doors have a keyless bolting device, again, installed in accordance with the property code. So that is the third exception that you'll run into for those Category 1 requirements. Now, what happens if a landlord falsely claims one of these exceptions? Well, the landlord can be subject to liability. No surprise there. So it's very important that if you're relying on one of these exceptions, that it is in fact the case, that all of those things are accurate. So these types of security devices, these Category 1 security devices, have to be operable throughout the time the tenant is in possession. However, there is, of course, a slight exception to that. A landlord can deactivate or remove the locking mechanism of a doorknob lock or remove any device not qualifying as a keyless bolting device if a keyed deadbolt has been installed on the same door. It's important to note, if one of these security devices is missing, it's not installed, the tenant can request the landlord to immediately install it, and the landlord must actually immediately install it. So in addition to installation requirements, there are also requirements involving rekeying. And what do we mean by rekeying? Well, rekeying means to change or alter a security device operated by a key or a card so that a different key or card or combination is necessary to operate that security device. So what the property code requires is that a security device operated by a key, card, or combination has to be rekeyed by the landlord at the landlord's expense, not later than the 7th day after each tenant turnover date. Tenant turnover date means the date a tenant moves into a dwelling under a lease after all previous occupants have moved out. It does not include dates of entry or occupation not authorized by the landlord. So you'll note that generally rekeying has to be done at the landlord's expense. Well, a couple of years ago, a change was made to the security device requirements, or that chapter, or subchapter rather. And what it now says is that if a tenant vacates the premises in breach of a written lease, the landlord can actually deduct from the security deposit the reasonable cost incurred by the landlord to rekey the security device, but only if the lease contains a provision that's underlined or printed in boldface type authorizing the deduction. JR's lease has that language. And so again, it's just the idea that generally rekeying is at the landlord's expense, but there is an exception if the tenant leaves the lease or terminates the lease early. Now we're switching categories here. We're switching to those category 2 requirements, the security devices that the landlord must install at the tenant's request at the tenant's expense. So, at a tenant's request made at any time, a landlord at the tenant's expense must install a key deadbolt on an exterior door if the door has either a doorknob lock but not a key deadbolt, or a keyless bolting device but not a key deadbolt or doorknob lock. So remember, one of the requirements that a landlord has to equip the dwelling with was either a doorknob lock or key deadbolt. So this is something where, for instance, under 1, the tenant could request that if it has a doorknob lock, they also want a key deadbolt, even though technically under those category 1 requirements, the landlord would not have had to install both. The second here is a sliding door handle latch or a sliding door security bar if the door is an exterior sliding glass door without a sliding door handle latch or sliding door security bar. So again, remember, category 1 requirements say that the property has to be equipped if it has a sliding door with a sliding door handle latch or a security bar. So the tenant could ask for one or the other if only one is present, which is allowed. And just like the previous category, in addition to installation for those category 2 security devices, there are also requirements involving rekeying. So at a tenant's request made at any time, a landlord at the tenant's expense must perform additional rekeying or change a security device. Now, a tenant can make an unlimited number of requests under this particular subsection. One thing to note, however, that the expense of rekeying security devices for purposes of the use or change of the master key is actually paid by the landlord. But otherwise, again, additional rekeying requests, that is at the tenant's expense. So the tenant can request these items. How do you actually give the request, or how does the tenant have to give that request? Well, the request can be given orally unless the lease requires the request or notice to be in writing, and that requirement is underlined or boldface. So if you're using the TAR residential lease, it requires the request to be in writing and complies with that particular provision. What's the timing on this? How much time does a landlord have to comply with a tenant's request under these category 2 security devices? Well, a landlord has to comply with a tenant's request within a reasonable time. So what does that mean? What's a reasonable time? Well, it's presumed to be not later than the 7th day after the date the request is received by the landlord. Now, again, there's a lot of exceptions. We've heard about a lot of exceptions today, and this is no different. In particular circumstances, a reasonable time could be shorter. It could be not later than 72 hours after receipt of the tenant's request and any required payment if the tenant informs the landlord that there's been an unauthorized entry or there's been a crime of personal violence. That can shorten that reasonable time presumption of 7 days to 72 hours. Now, what about a landlord defense? What if they fail to timely comply with their request? Well, there is a defense that a landlord can use. They can rebut the 7-day presumption if, despite their diligence, they made the effort, but the landlord did not either know of the tenant's request, and it wasn't their fault for not knowing, material, labor, or utilities were unavailable, or another option is that a delay was caused by circumstances beyond the landlord's control, including illness or death of a landlord or a member of the landlord's immediate family. Those could all be used as defenses to why the landlord was unable to timely comply. Now, again, just as a reminder, the 7-day timeline doesn't apply to those Category 1 security devices. Those are things that have to be done immediately. But for Category 2, there is that 7-day timeline presumption. What about advance payment? You've got a tenant making these requests. Can you require advance payment? Well, yes, in certain situations. So a landlord can require a tenant to pay in advance if, 1, a written lease authorizes the landlord to require advance payment, and actually the TAR lease does. It has that language. Second, the landlord notifies the tenant within a reasonable time after the tenant's request that advance payment is required. And then third, one of the following occurs. 1, that the tenant is more than 30 days delinquent in reimbursing the landlord for charges to which the landlord is entitled under subsection B. What is that? That's talking about repair or replacement because of misuse by a tenant or the tenant's family or a guest or occupant. So that's one of the situations which could trigger advance payment. The other is the tenant requested that the landlord repair, install, or rekey the same security device during the 30-day preceding period, and the landlord actually complied with the request. So you can require advance payment when all of those things are true. Now, when advance payment is required, again, a reasonable time is presumed to be not later than the 7th day after the date the tenant's advance payment is received, of course, unless that 72-hour exception applies. So if advance payment, if you can require that, then the 7th day requirement or timeline moves from not only the date of receipt of the request, but also receipt of advance payment. So we've talked about Category 1 security devices. We've talked about those Category 2 security devices. What about repair or replacement of security devices? So there are specific requirements for repair or replacement. During the lease term or any renewal period, the landlord does have a duty to repair or replace a security device on request or notification by the tenant that the device is inoperable or in need of replacement. So what's the time for that? Well, this should be very familiar. This should be familiar language. A reasonable time, presumed to be the 7th day after the request is received by the landlord. Of course, there is that same exception, that 72-hour exception, if it's an unauthorized entry, crime of personal violence, things like that. There's that same defense, that same landlord defense to not being able to timely comply if the landlord didn't know without fault of the landlord about the tenant's request, material, labors, or utilities were unavailable, or delay outside of the landlord's control happened. So same language there for repair or replacement. Who pays for a repair or replacement? Well, generally, a landlord may not require a tenant to pay for a repair or replacement of a security device due to normal wear and tear. And normal wear and tear, of course, means deterioration that results from the intended use of a dwelling due to, age or deteriorated condition, but does not include deterioration that results from abuse or carelessness or negligence. So again, ordinarily, a landlord cannot require a tenant to pay for repair or replacement due to normal wear and tear. But a landlord can require a tenant to pay if there's an underlying provision in a written lease authorizing the landlord to do so, and the repair or replacement is caused or needed because of misuse by the tenant or the tenant's family or an occupant or a guest, and not by normal wear and tear. So you may be thinking, well, the tenant might just say, well, it wasn't me, or it wasn't my family, or it wasn't a guest, it was someone else, or it was caused by something else. And misuse or damage to a security device that occurs during the tenant's occupancy is presumed to be caused by the tenant or their family or an occupant or a guest. And the tenant actually has the burden of proving that that damage was caused by another party. So if it's normal wear and tear, the landlord pays, but if it's something beyond that, the tenant can pay. Now, how much can a landlord charge? If the tenant is required to pay, how much can the landlord charge? Well, generally, the landlord's authorized to charge a tenant for repairing, installing, changing, rekeying a security device, cannot require the tenant to pay more than the total cost charged by a third party. There are some exceptions, however. So if the landlord's employees perform the work, the charge could include overhead but not profit. If the management company employees perform the work, the charge could include overhead and profit, but could not exceed the cost charged to the owner by the management company for a comparable security device installed by the employees of the management company at the owner's request. Additionally, a landlord must reimburse a management company or an agent for costs expended by that person in complying with these security device requirements. So that's good for you all that are property managers. A management company, agent, or on-site manager can reimburse himself or herself from the cost from the owner's funds in its possession or control. And if you're using the TAR property management agreement, the broker does in fact have the authority to pay reimbursements due to the broker. Okay, so we've talked about the requirements. What happens if the landlord fails to comply? What remedies can the tenant seek? So what if the landlord fails to install a security device that is required without a tenant's request, a Category 1 security device? Or what happens if the landlord fails to rekey as they're required to do after the tenant turnover date within the time required? What can the tenant do? Well, the first potential remedy is that a tenant could install or rekey the security device and deduct that cost from the next rent payment. Now, there are very specific requirements for this, as you might imagine. Those are in Section 92.166 of the Property Code, but that is a potential remedy if the tenant complies with those requirements. Another option is that the tenant could serve a request for compliance on the landlord. And if the landlord does not comply on or before that third day after the notice is received, the tenant could actually terminate the lease without going to court. Now, note that third day requirement. There is actually a pretty lengthy provision in the Property Code that actually says that the timeline can be changed from 3 days to 7 days if a lease contains very specific notice information. TAR lease does not have this, but if you're interested in exploring that option, that is an option in the property code to change that timeline from 3 days to 7 days. The third option that a tenant could potentially pursue is they could file suit against the landlord without serving a request for compliance and get a judgment for all of these things. A court order directing the landlord to comply, actual damages, court costs, and attorney's fees. Now you'll note I've bolded the "and" in number 4 there. And the reason for that is that these remedies are not mutually exclusive. In theory, a tenant could pursue all of these remedies if it made sense to do so, or one, it would be up to the tenant. But these are all things that a tenant could pursue. So the fourth option here is that a tenant could serve a written request for compliance. If the landlord doesn't comply on or before the 3rd day, they could file suit against the landlord and obtain a judgment for these 6 things: a court order, actual damages, punitive damages if the tenant actually suffers actual damages, a civil penalty of 1 month's rent plus $500, court costs, and attorney fees. So that can be a pretty serious situation. I'll note again, on or before the 3rd day, that timeline can similarly be changed from 3 to 7 days if your lease has those very specific notice requirements or language. Again, you can check out the property code if you're interested in looking into that. Okay, so we talked about what happens if the landlord fails to install those Category 1 security devices or fails to rekey as required. What happens if the landlord fails to install, rekey, repair, or replace a security device as required after a tenant's request at tenant's expense? Well, they're pretty similar. There are 3 options here instead of 4, but the first is that, again, the tenant could install or rekey the security device and deduct those costs from the rent payment. The tenant could unilaterally terminate the lease without going to court, or the third option, and I should say, and the third option is file suit against the landlord and obtain a judgment for those 6 items. So similar remedies to those Category 1 security devices. Now, what about a defense for the landlord? Well, one of the defenses that a landlord could use if they fail to install a required security device or rekey as required by the property code, one of the defenses could be if the tenant has not fully paid rent. So a landlord has a defense to liability if the tenant has not fully paid rent, all due at that point from the tenant on the date the tenant gets a request under one of these 2 sections. Basically, requesting those mandatory security devices be installed, or providing notice that the landlord has failed to install or comply with those mandatory security device Category 1 security devices. The second defense is that the tenant has not fully paid costs. Well, what does that mean? Well, a landlord has a defense to liability if the tenant, on the date the tenant terminates the lease or files suit, the tenant has not fully paid costs requested by the landlord and authorized by Section 92.162. That's the section which deals with requiring the tenant payment of repair costs or advance payment. So those are 2 defenses the landlord could potentially use. What about for a defense when the landlord has failed to comply with the tenant's request? Well, there's that similar defense that tenant has not fully paid costs. A landlord has a defense to liability under this section, 92.165, which deals with additional routine security devices required without a tenant's request and duty to repair if on the date the tenant terminates the lease or files suit, they have not fully paid costs required or requested by the landlord. And then, of course, also remember the defense the landlord has if the landlord fails to take action within the time required, that those three things, the landlord didn't know, there wasn't sufficient material or labor, or it was beyond the landlord's control. So those are some of the landlord's defenses. What about property management or property manager defenses for a tenant's request? So a management company or a managing agent who is not the owner and who is not purported to be the owner in a lease has a defense to liability if before the date the tenant is in possession or the date the tenant's request for installation occurs and before any property damage or injury to the tenant, the management company does these three things. The management company or managing agent did not have the funds from the owner in its possession or control with which to comply with the security device requirements. The management company or management agent made written requests to the owner that the owner fund and allow the installation or repair of security devices as required, and in fact mailed that request, certified mail return receipt requested to the owner. And then third, not later than the third day after the date of receipt of the tenant's request, provides the tenant with a written notice stating that the company or the agent has taken the actions identified in 1 and 2, stating that the owner has not provided or will not provide the necessary funds, and 3, explaining the remedies available to the tenant for the landlord's failure to comply. And those remedies would be that, the tenant can unilaterally terminate the lease or exercise other remedies under the security device subchapter sections 92.164 and 92.165. Now, many of your heads may be spinning. This is a lot of information to go over, and there's a lot of very specific details when we talk about security device requirements. So we have created a cheat sheet that will hopefully be helpful to you when you're trying to look at what is actually required under the property code. So you'll see this chart breaks down the security device categories, category 1, category 2, and then also has a column for repair or replacement, and then it addresses time, how quickly or how soon does the landlord have to comply, who has to pay, what the potential remedies are for a tenant under each category, and what the potential defenses are for a tenant under each category. So hopefully that will become helpful or be helpful for those of you who want to look into this a little bit more. So that concludes the lecture portion of this presentation. One thing I want to mention before I open it up to questions is we do have a security device flow chart, which I think is helpful in trying to understand or grasp all these requirements and what exactly they entail. So if you want to check that out, that is actually available on our website, texasrealestate.com. It was in a Texas Realtor magazine edition. It was September-October 2012. You can actually find the archived issues of our magazine on our website. So that may be a helpful tool for you to use. And then finally, of course, if you have questions that we don't get to today or if you think of later, you can always call our legal hotline at 512-480-8200. So let's open it up to questions now. Go ahead and type those questions in if you have them. So the first question here. So the first question is, does a rod placed in the track of a sliding glass door qualify, or does it have to be mounted to the door? So what I think this person may be asking is about the security bar. So if you go back to that definition, a sliding door security bar is a bar or rod that can be placed at the bottom of or across the interior side of the door of a fixed panel, and it's designed to prevent the door from being opened. That is the definition. There isn't a specific requirement there. It can be at the bottom or it can be across the interior side. Either way, it's a bar rod that is designed to prevent the door from being open. So that's the requirement. If you're finding that there are different methods to do that, then that would certainly comply. You just have to look at that definition. Remember, the pictures that I showed you were for representation only. Look at the definition when you are trying to ascertain whether you are in compliance or not. Next question here. The question is about temporary residential leases and just a refresher about whether those items are required, whether security devices are required. The answer is no, that while generally security devices have to be in most types of rental property, one of the exceptions is for a temporary residential lease of a term not to exceed 90 days. So that is an exception, meaning that you do not have to comply, landlords, if it is a temporary residential lease. So another question we have here is, do you have a chart of approved security devices or keyless locks available to download similar to your rekey timeline flow chart? We don't. That's a good idea, though. I know that there are companies out there that specialize in this area, and so that's something that they may have available or can talk to you about. But that's a good idea. We should look into that. We don't currently, however. About questions about the recording and slides. So yes, slides are available right now. I know this was a lot of information, so if you want to download those slides, those are available on our events page of our website, texasrealestate.com. If you go and find the webinar link for today's webinar, it's on that page. Recording, same deal. The recording will be posted on that events page. And actually, in about an hour, you will receive a follow-up email. It will contain a link to that recording. Okay. Another question here. So if some of the tenants renting a particular property move out, am I still required to rekey? So I think the question here is if some but not all of the tenants move out. And the answer is no. Remember the definition of a tenant turnover date. It's defined as the date a tenant moves into a dwelling under a lease after all previous occupants have moved out. So if it's only a few, one tenant out of 4 moves out, that's not what triggers the rekeying requirement. The tenant turnover date specifies all previous occupants. Okay, going through questions here. Some of these are a little specific, so I'll encourage you for these really specific questions about really specific types of properties to call the legal hotline. So I've got a question here about garage door openers. So what's interesting is that this statute, I think, was first enacted in 1993. I know garage door openers were around at that point, but perhaps were not as prevalent. And there are a lot of other electronic security devices at this point. So the statute, to answer your question, isn't specific about garage doors or what is required. And that's perhaps something that the legislature may look at in the future. But in terms of what the security device requirements are, there's nothing specific about a garage door opener. Now, from a practical standpoint, is it a good idea to consider whether you should change the code? And sure, that's something that could assist with safety for the next tenant occupying that property, but in terms of that specific security device subchapter, a garage door opener is not addressed. Okay, so it looks like those are all the questions that we've got for today. If I didn't get to your question, again, feel free to contact our legal hotline, 512-480-8200. Thank you, everyone, for joining us today and for participating in our last webinar for 2018 for our property management webinar series. Stay tuned for dates for next year. I hope everyone has happy holidays and a happy new year. Thank you, everyone.